I tell you about the case because by the time most people hear about cases like this one, the person at the center of it has already become a number in a file. She was not a number to me. She never was. I have held this story for a long time, not because I was afraid to tell it, because I wanted to tell it right. Subscribe and turn on notifications. That is the only reason I am here today, to tell it right to the right people. Subscribe before I keep going. I want to start with one fragment of a moment, the silence after I spoke the sentence. I am going to return to that silence in full before this is over, but I want you to know it was there. A room that had been loud with procedure and argument, and something close to anguish went completely still. Not the still that happens between words. The still that happens when something permanent has entered a room and everyone in it knows it. I was on that bench and I could hear myself breathe. That is where this story ends. Now let me tell you how it got there. Maya Osi was 31 years old at the time of the incident. She worked as a home health aide. 7 years of going into people's homes when they could not care for themselves and doing what needed to be done with a steadiness most people do not have. When she walked into my courtroom for the first time, she walked in the way people walk when they have spent years moving through other people's pain carefully, like she was always a little aware of the space around her, a little conscious of not taking up more than she needed. She sat in the gallery and folded her hands in her lap and looked at the front of the room, not at him, at the flag in the corner. I notice where people look when they sit down. After 22 years on this bench, you learn that it tells you something about what a person is preparing themselves for. The one thing I have not forgotten about Maya, and it was not dramatic, which is exactly why I have not forgotten it, is that on the second day she brought a small notebook. She wrote in it during testimony, not constantly, occasionally in a careful hand, like she was keeping track of something for herself, not for the record, for herself. I watched her write in it and I thought, she is making sure she remembers this correctly. She is that kind of person. The defendant's name was Carter Aldridge, 24 years old. His father was a state assemblyman. I tell you that not to frame what comes later, but because it is true and because it explains why the case arrived on my desk the way it did. With a defense team assembled quickly and expensively, with motions filed before the ink was dry on the complaint. Carter walked in on the first day in a suit that fit him well, and sat down with the ease of someone who had always been somewhere arranged for him. He did not look nervous. He looked like someone waiting for an appointment that had been made on his behalf. What I found genuinely human about Carter, and I want to be honest about this, was a moment on the second day when a line from Maya's impact statement was read into the record, something about the way the incident had affected her ability to sleep. Carter looked down at the table, not theatrically. He looked down the way someone looks when something has actually landed. It lasted 4 seconds. Then he was back to the same composed expression. But I saw it, and the reason it made everything worse rather than better is this. It told me he understood. He understood what he had done, somewhere underneath the posture and the prepared answers. He understood and had still allowed his attorneys to argue otherwise for 2 full days. Let me tell you about March 14th, a Tuesday afternoon, 427 Sycamore Avenue at the intersection of 12th Street. A police motorcycle escort was moving through a green light, lights and sirens active. It was running ahead of an ambulance carrying a 67-year-old man in cardiac arrest. Every driver on Sycamore was pulling right. Every driver except one, a black SUV with tinted windows and a private plate registered to the Aldridge family, pulled forward into the intersection and stopped. The officer on the lead motorcycle braked hard enough that the bike went sideways. He went down on the pavement. The motorcycle slid 31 feet. The officer fractured his wrist and tore a ligament in his shoulder. The ambulance rerouted. 4 minutes and 17 seconds added to its transit time. The man in the back did not survive. He was pronounced dead at 5:12. Carter Aldridge was behind the wheel. In testimony, when asked why he had not pulled right with every other vehicle, he said, and I am quoting him exactly, he said, I didn't think the rules applied the same in a situation where someone in my position would have faster access to private care if there were an actual emergency. I wrote that down. Not for the record was already keeping it. I wrote it down because I needed to sit with it. If something in what I have said so far has stayed in your chest, subscribe. Because what I am about to tell you next will stay longer. Subscribe now and then, let me keep going. Before the case came to my courtroom, there were weeks of procedural movement. A complaint filed by the department, a civil claim filed separately. The defense entered a motion to dismiss the criminal reckless endangerment charge, arguing the defendant had not been operating in a restricted zone. That motion was denied, but the process required 11 days of review. What most people do not know is that victims and their families have no standing in pretrial motions. None. Maya was not notified when the motion was filed. She learned about it after the fact, from someone who remembered to mention it. I think about those 11 days. I want to be clear about the limits of what I could do. I could rule on what was in front of me. I could not control what arrived on my desk or how the people affected by it were informed. That is the truth of this work. I say it not as a complaint, as a fact that people sitting in those galleries deserve to know. Now let me tell you about Silence 1. The first silence happened on the third day. Maya took the stand. She sat straight, held the water glass with both hands, answered early questions the way someone answers things they have practiced. Then the prosecutor asked her to describe the moment she found out her husband had gone down. Not the medical facts, the moment itself, where she was, what she was doing. Maya was quiet. Then she said, "I was folding laundry, his laundry, and my phone rang and it was his watch commander and I thought he was calling about weekend plans because we talked about that. I thought that's what it was." The courtroom went quiet, completely. The kind of quiet where you become aware of the ventilation system. 9 seconds, I counted. The court reporter's hands were still on the keyboard. No transcript being made because no one was saying anything. The silence was broken by Maya herself, who drew one breath through her nose and said, "Okay, what's the next question?" Not a question, a statement, like a person who knows the only way through a thing is through it. I understood something after Silence 1. There is a kind of strength that is not courage, it is just the absence of any remaining choice. Maya was not brave on that stand in a way that felt elevated. She was simply continuing, because stopping was not available to her. From that point, the evidence came in steadily. Dashcam footage from a vehicle 2 cars back was entered into evidence. I reviewed it twice. It showed every car in the lane yielding and the Aldridge SUV moving forward and stopping. It showed the officer's motorcycle going sideways. It showed 11 seconds between the motorcycle going down and Carter opening his door. 11 seconds. He sat inside the vehicle for 11 seconds before he got out. The ambulance rerouting was documented by dispatch records. A cardiologist testified in plain language about what 4 additional minutes means in a cardiac arrest event. I do not need to translate that for you. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. My father drove a delivery truck for 31 years. He told me once about a car that ran a red light and clipped his bumper. He was fine. The truck was fine. But he told me about it at dinner, and what he said was, "I didn't honk, I just made sure everyone else was okay, and I moved on." He was not a man who told stories about himself. He told me that one because it surprised him, that his first instinct was to check on the other people. Not to be recognized for it, just to act on it. I thought about that story throughout the 5 days of this case. I did not think about it as a lesson. It was just something I had been carrying that found its place in the room with me. The defense called Carter to testify on the 5th day. He said he had not heard the sirens clearly because the sound system was on. He said he had looked right and had not seen other vehicles yielding. He said when he understood what was happening, he had pulled forward to clear the intersection, not to block it. He said, "I would never intentionally obstruct an emergency vehicle. I have the deepest respect for law enforcement." He said it the way someone says something they believe they are supposed to feel. The defense attorney made a genuine argument. They argued that the defendant's action, however the outcome appeared, was not willful, that there was no intent to block an emergency vehicle, that the tragedy of the outcome did not transform the act into a crime of intent. They were not wrong that intent matters in law. They came closest to giving me real pause in closing, when the attorney said we cannot assign criminal weight to mistakes that carry civilian consequences. I sat with that evening. I read the statute again. I read the case file again. What ended the pause was not an emotional conclusion. It was the 11 seconds. Carter Aldridge sat inside that vehicle for 11 seconds. The dash cam did not record confusion. It recorded stillness. He said one other thing in testimony that he did not know he was telling me. He was asked whether, in the moment he realized what was happening, he had tried to contact anyone. He said, "I texted my father's assistant to let him know there might be a situation." He said it as if it were the obvious first call, as if it were the reasonable thing to do. I wrote it down. I looked at it for a long time before I moved on to the next page. Subscribe. I owe it to her to keep telling this story. You subscribing is how her story reaches past this video. Subscribe and stay. After deliberation, the jury returned a guilty verdict on the criminal reckless endangerment charge. I had that and the civil contempt finding both in front of me at sentencing. I had made this decision carefully. I had made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case they were. When I read the sentence, the room went completely still. Silence 3. I will come back to the full weight of it. But first let me tell you exactly what I ordered, in the same voice I used in that courtroom. I looked at Carter Aldridge and I spoke. I am ordering you to pay a fine of $75,000 directed to the Emergency Medical Services Training Fund for this district. An ambulance was delayed because of a decision you made. You will pay into the system that trains the people who run those vehicles. You will contribute to making them more prepared for the next time someone does not yield. I am also ordering the suspension of your driver's license for 3 years, not a restriction, a suspension. You will not operate a motor vehicle on a public road for 36 months. During those 36 months, if you have an emergency, you will call the same services you prevented from reaching theirs on March 14th. You will wait for them like everyone else waits. You will serve 200 hours of community service, not general service. You will serve those hours as a ride-along observer with the paramedic units of this district. You will accompany emergency medical crews on active calls. You will not speak unless spoken to. You will watch what this work looks like from inside the vehicle, all 200 hours. You will provide quarterly sign-offs to this court from the supervising unit commander. You will write a public statement, no less than 500 words, published in the record of the district assembly in the town where you live, and in a publication approved by this court. That statement will name what you did on March 14th. It will name Officer Osei by name. It will name the 4 minutes and 17 seconds. It will not use the word accident. And finally, Officer Osei has been in physical therapy for his shoulder since the incident. You will pay for that therapy in full for as long as it is medically required, submitted quarterly and reviewed by this court. You will not negotiate the duration. You will not set a cap. The treatment ends when the doctor says it ends. I want to speak to you directly, Carter. You blocked an emergency vehicle, not a misunderstanding of traffic law, not a miscalculation. You moved your vehicle into an intersection where every other driver had responded correctly, and you stopped it there, and an officer went down, and an ambulance was delayed, and a man died. I am not saying those things as accusations. They are in the record. They will remain facts regardless of how many appeals follow. To your family, I understand what it is to hear a sentence read for someone you love. I am not speaking to you with anger, but I ask you to consider what it means to stand next to someone through consequences rather than having done so differently at the beginning. You are a young man whose father held a position of public trust. That position required something of you by proximity. It required understanding that the systems your father worked within, including emergency services and traffic law and the obligation to yield, were not less binding on you because of his name. They were more binding. You had more reason to understand them. You chose differently. The last thing I said in that courtroom was not about Carter Aldridge. It was about Maya Osi. I said, she came here every day to make sure this was done correctly. She will leave having done everything available to her to do. That is a specific kind of integrity, and it deserves to be said aloud in this room before we close. Now silence 3, fully. The room after I finished speaking. Carter's lead attorney set his pen on the table and did not pick it up for a long time. Carter did not move. The court reporter's hands were still. 11 seconds, the same as the dash cam. I do not know if anyone else in the room counted. I did. Then from somewhere in the gallery there was a single long exhale, a breath someone had been holding. The room began to move again, papers, chairs, the ordinary sounds of a place returning to itself. Before silence 3 there had been a second silence I want to name now. On the 5th day, after Carter finished his last answer in testimony, a long, carefully constructed answer about his understanding of traffic law, the prosecutor said simply, "No further questions." The room went quiet. But this silence was nothing like silence 1. Silence 1 had the quality of something held in too long finally being released. This silence had the quality of something that had come up empty. The jury member in seat 4, who had been leaning forward through all of Carter's testimony, sat back in his chair. I wrote one note to myself in that silence. I wrote, "He never asked about the officer." In 5 days of proceedings, in 2 hours on the stand, Carter Aldridge had never once asked how Officer Osi was doing. I am not drawing a conclusion for you. I trust you to sit with it. Subscribe before I go further. I have more to tell, and the more I tell, the more it matters that someone is listening. Subscribe and turn on notifications. Then let me continue. The defense filed an appeal within 40 days. It was heard by the appellate division 8 months later. The ruling upheld the conviction. It upheld the license suspension and the community service. The fine was reduced by $12,000 on a technical filing classification that had nothing to do with what he did. 8 months. One number changed. I had expected something like it. You do this work long enough and you understand the system is right, more often than it is wrong, but it is never entirely clean. That is the truth, and I am not going to offer you a different one. On November 9th, 7 months after sentencing, the court's compliance officer told me that Carter Aldridge had completed his 48th ride-along hour with the paramedic units. She mentioned it as routine. What she added, unrequested, was that the supervising unit commander had written a note in the log. It said, "He asked good questions today." I have turned that over more times than I can count. I am placing it here for you. I am not telling you what it means. I do not know what it means. I only know it happened. This case left me with a question I have not set down, not a legal question. The legal question was answered. The question is this: at what point does a person become genuinely unable to perceive that the rules apply to them the same as to everyone else? Not unwilling, unable. I do not know the answer. I have thought about it for more than a year, and I still do not know. What I know is that the gap between unable and unwilling is the gap the sentence was trying to address. I do not know if it succeeded. I know it tried. Grief and clarity are not opposites. In my experience, one tends to produce the other if you sit with it long enough. I have sat with this one long enough to know what I think. I am not certain I am right. I am certain I was honest. To anyone who has sat where Maya sat, not in that courtroom specifically, but in any place where you waited for a system to catch up to what you already knew was true, where you brought a small notebook and wrote things down because you needed to make sure you remembered it correctly. I want to name what I saw in her face during those 5 days. It was not defeat. It was not hope exactly either. It was the face of someone who had decided that showing up was the one thing she could control, and so she was going to show up completely. I have seen that face before. It does not ask for recognition. It does not get enough of it. If you know that face from the inside, I saw it. It mattered in that room. To anyone who has moved through the world with the assumption that certain structures are for other people, I have one question I could not ask from the bench because it was not a legal question. When did you last think about what it would cost someone else for you to be wrong? Not in the abstract. Specifically, one person, what it would cost them. I offer that not as accusation, as an invitation. It was available to Carter before March 14th. It is still available to you. I watched the courtroom empty from the bench. I stayed seated while chairs scraped and attorneys packed and the gallery filed out. Maya stood slowly. She closed that small notebook and tucked it under her arm. She said something quietly to the woman beside her. The room was quiet enough that I heard it. She said, "He saw us." I do not know who she meant by that. I have thought about it since. When the room was almost empty, I finally stood. I looked at it, smaller than it always seems when it is full, and what I noticed was that it was just a room, 4 walls, fluorescent lights, the flag in the corner, chairs that needed pushing back in. Someone would come before morning and do that. That was the last thing I noticed before I walked out. Thank you for staying with this. I mean it in the specific way you mean something when it cost you something to say. Subscribe if you have not yet. You already know why you are still here. The comments on these videos tend to find the right people, the ones who came here because they believe what happens in those rooms matters beyond the people who happen to be in them. If that is you, say something. You will find others there.